Mr. Nomalo, you're saying you just need a week.
Yes, I think there must be clarity, my lord. What this entails is that when the court is not sitting, legal aid is not paying. So this in-trial is when the court, like today, in-trial preparation 2 hours, then there's payment. Then there's payment for court appearances. So when the issue with my colleague is that when the matter is postponed, say for a week or 2 weeks, then there's no payment at all. But I'm saying on top of that, with or without any payment, I'm prepared to proceed to bring an application on the 18th of August 2025.
And you just need a week to prepare?
Yes, a week.
Mr. Minister, are you saying a week to prepare won't be sufficient for you?
Well, my lord, if...
No courtroom drama, no witness stand battles, just words on paper, but words that could decide the fate of 5 men. On August 15th, the defense in the Senzo Meyiwa trial will quietly drop their written submissions. And while it might seem uneventful, make no mistake, this could be the most calculated move of the entire trial. Because in the silence of that courtroom, the real fight will be happening on the judge's desk. Today, we break down what those arguments are likely to say, how they might be crafted, and whether they have any chance of changing the outcome. First, let's understand what the 15 August deadline really means. This isn't a hearing date. You won't see advocates cross-examining or Judge Ratta throwing sharp remarks. Instead, it's paperwork day, but paperwork with very high stakes. This is where each defense lawyer gets to compress their months of cross-examinations, objections, and courtroom strategy into one single document for the judge to study. And unlike the daily grind of witness testimony, this document isn't limited by the emotions of the moment. No interruptions, no objections, just a carefully curated version of reality, as the defense wants Judge Ratta to see it. Remember, these submissions are not for us, the public. They are aimed entirely at one audience, the judge, which means every sentence is designed to plant reasonable doubt in his mind, frame the narrative, and lock in a legal escape route for their clients. So, what can we expect inside these submissions? Based on everything we've seen in court, 3 major themes are almost certain to dominate. Theme 1. Insufficient evidence. Expect the defense to hammer on the lack of direct, credible, and uncontested evidence linking their clients to the actual shooting. They'll highlight how much of the state's case rests on circumstantial evidence, disputed confessions, and cell phone data that has been challenged for reliability. Theme 2. Contradictory testimony. They will almost certainly dedicate pages to dissecting inconsistencies, not just between different state witnesses, but also between a single witness's own statements over time. Remember Brigadier Geninda's shifting explanations, or the different versions from Zandile Khumalo. Those will be framed as signs of unreliability and possible fabrication. Theme 3. Missing links in the chain of evidence. This is where they'll get technical, pointing to alleged procedural irregularities, evidence collection gaps, and forensic blind spots. They'll argue that without a clear, uninterrupted chain from the crime scene to the accused, the entire case becomes speculative. The tone? Expect precision. The defense will strip away emotion and focus on cold procedural law because that's where reasonable doubt thrives. But here's the wild card: legal aid. We know there's been tension over whether the defense has had the resources to fully prepare these submissions. Legal Aid South Africa's budget isn't infinite, and high-profile cases like this one burn through funding quickly. If resources are tight, that could mean fewer expert reports, less intensive case law research, and a heavier reliance on oral arguments later. The lawyers may be forced to save their heaviest punches for the 25th August oral arguments instead of blowing all their ammunition on paper now. On the flip side, budget constraints could also sharpen their focus. A leaner, more targeted document might actually make a stronger impact if it zeroes in on just 2 or 3 killer points instead of drowning the judge in a 200-page legal swamp. Of course, the prosecution won't just take this lying down. Baloyi and his team are likely already preparing counter-arguments to preempt what the defense will say. They'll argue that while there may be inconsistencies, they are normal in human memory, especially after years have passed. They'll reframe contradictions as minor details that don't shake the core truth of the state's case. On evidence gaps, expect Baloyi to lean heavily on the totality of evidence principle, the idea that the case must be viewed holistically, not picked apart piece by piece. And when it comes to witness credibility, they'll point to supporting forensic, ballistic, and digital evidence to argue that even if a witness stumbled, the overall case remains strong. Now, here's the big question. Will any of this actually sway Judge Rutter? If we're being brutally honest, probably not in a dramatic way. Judges rarely do a 180-degree turn because of written submissions at this late stage, but that doesn't mean they're irrelevant. These documents can sharpen the focus of the final oral arguments, give the judge legal hooks to hang a reasonable doubt verdict on, and create a cleaner record for appeal if the defense loses. So while they might not directly flip the outcome, they could very well shape the path to that outcome. And that brings us to 25th August, the real stage for fireworks. This is when both sides will face off live, verbally, and with no second chances. The written submissions on the 15th are just the opening act. The oral arguments will be the closing showdown. The defense's last gamble begins on paper, but its success will be decided in the flesh in front of Judge Rutter 10 days later. So, will the defense's written submissions on the 15th be the silent game changer they hope for, or just a carefully worded last stand? We'll be watching closely. Subscribe if you want the breakdown the moment we get our hands on them, because in this trial, even the quiet days
what you
speak
perceive
volumes.
to be the factors that you will include or that will fortify your application later at the end of the state's case for an application for discharge. But because this has been a long-running matter, yes, for myself, and I'll speak for myself, I have identified issues that I say this will assist my client in his application for a discharge in terms of Section 174. Yet now, I need to go and identify that evidence in the transcripts themselves. I'm not going to read the whole transcripts. I'm identifying an issue so that when I say, Madala said this, I can tell the court and say, here's the contradiction that lies there, according to the transcript. So that's exactly what we are perhaps not finding each other for. This is not a shoplifting case of two witnesses in a district case, magistrate's court matter, where the state finalizes two witnesses, then you apply for 174 because somebody stole a perfume or whatever at the store. But this is a serious matter where you need to identify crisply the issues that you want to raise. And as Mr. Munisi says, you don't want to bring a half-baked case to court, my lord. So perhaps that's the issue. The issue is not finances per se. The issue is preparation time. That you are told X, Y, Z, but that's for me the clarification. I know the issues that I've identified for this particular application.
So what should we do?
I think the parties should be allowed to explore